Good afternoon and good morning, everyone. This is Kylene Golubski, Executive Director of the M&A Source and the IBBA. Glad to have you with us again for this continuation webinar, which I have to say, these series of webinars are pretty much the ones we've had the greatest registration for. So we know this is an area of interest. We know this is an area where there continue to be questions. And so the M&A Source and the IBBA are working together along with great folks like Mike Ertl and Shane Hansen to answer your questions and bring you the updates as we know them. Before we jump in, a couple quick housekeeping items. You do have a control panel on your screen that you can click and drag around to your liking. There's also an arrow towards the upper left that you can click on that will completely minimize that control panel, and you just click on it again to bring it back out. There's a questions section on your panel, and you can type your questions in there. We have a bunch of questions that were pre-submitted that we're going to go through. Shane's actually prepared some slides that I think are going to answer many of those. And then we do have your pre-submitted questions, but go ahead if you still have a question, type it in there and we'll leave some time at the end to go through some more of them. And if you weren't on our first webinar and maybe are not completely up to speed on kind of where things stand with this, I'm going to do a less than a minute recap of some things that we know that there are a lot of basic questions around, and there tend to be some misunderstandings regarding. So the first is that these webinars, the information we're providing you with is not to be considered legal advice. There are many layers. There's lots of complexity here, things going on. So this in and of itself is not considered legal advice. Also a reminder that what we're talking about goes into effect at the federal level March 29th. And then we know that there's also sort of the whole layer and question of the state level, which Shane will get into for us. Also, this changes nothing about real estate laws. So we've seen many of your questions come in, how does this impact my real estate license that I'm required to have? Then there is no change. If your state requires you to maintain a real estate license, you still need that real estate license. Also, we know that there's a little bit of confusion sometimes because the law itself uses the term M&A broker. And we just want to clarify that in our vernacular, just think of that as business intermediary. If you're involved in brokering a business for sale that falls into the type of transactions that we're here talking about, then this law applies. So don't get caught up in the fact that the law so happened to use the term, M&A advisor or broker in its language. Many of you have asked, where can I get the text of the law? Where are the list of states? Where's the summary of the key provisions? All of that you can find on both the M&A Source and the IBBA websites. Both of them have a legal updates page. So to the degree that you have those questions, just know that's where those resources reside. And you will also find the recording of our first webinar last month, as well as this webinar's recording as we have it finished. And those are the websites to which we will continue to post any additional resources or updates that we have. So with that, actually, Mike, I'll turn things over to you because first of all, again, just a big thank you. You are one of the many folks who have been on this issue for almost 2 decades. To finally get this across the finish line. And this has been championed by the Business Intermediary Education Foundation, or BEEF, and is known as the Campaign for Clarity. So again, for our newer folks that are just getting up to speed on all of this, that's sort of the players and the entities involved. And now BEEF and Campaign for Clarity has been supported by M&A Source, IBBA, AMAA, other groups and organizations who had an interest in this subject. So broad and wide support for this legislation. Maybe you can just add a few more minutes in talking about BEEF, its purpose, its mission, and this journey.
Well, thank you, Kylene. Pleasure to be with you all today. The Business Intermediary Education Foundation was formed several years ago by some voluntary contributions from some founding members who felt that there needed to be an industry-wide resource to educate and create awareness of what business brokers do and the value they create for their clients and for the community. And the campaign for clarity started independently, but it very quickly became clear that it was an industry-wide campaign, and BIEF stepped in and agreed to help raise money to keep the campaign moving forward to the to today's date, where we've actually gotten a federal law passed that dramatically clarifies when does an M&A advisor have to have a securities license. I should point out that we've been working on this for about 16 years, and that as early as 2004 and 2005, some of the leading industry associations were concerned about how this affected their members. AMAA was actually looking to create a broker dealership to support its members who might need to have a securities license. IBBA had initiated an effort with an attorney to get the first no action letter issued by the SEC in 2006, the CBI no action letter. And we've been really working since then to try to clarify when does a business intermediary really need to have a securities license. So with that, we're pleased to announce that we did get a bill passed the end of the year. It takes effect March the 29th. And Shane, I'm going to transfer it to you to tell you more about it.
Okay, Mike, thank you. And thank you, Kylene. And thank you all for joining the program today. It is new for the industry to learn about this, and we know you've got lots of questions. We'll try to, in the recap of these slides, kind of cover the things that have most commonly come up in the presentations that we've given on this topic. And we'll pause after each of these bullet points in the presentation to allow a little more interaction. And actually, Kylene, if you can read questions that pop up in the questions or chat, I can probably easier respond to them, and we can get through them a little quicker. But we'll cover today what is the new federal M&A broker exemption. As Kylene noted, M&A broker is simply the handle that we used to describe the whole range of M&A related consultations, advice, exit planning. Some go on to broker or act as an intermediary. It covers all of that, and it covers basically all of the kinds of legal structures that an M&A transaction might take. So everything from a stock purchase and sale to a merger to a recapitalization where there's a change of ownership to business combinations. It really is designed to cover the waterfront. We'll talk about that a little bit more. We'll then turn to the states, and just the spoiler alert, we've got 20 states on board, but that does leave 30 to go. We'll talk about FINRA. How does FINRA apply? I could tell you there's a lot of folks who completely misunderstand FINRA's role in regulation. And so we'll talk about that. And we'll also talk about what is an M&A broker to do. We'll talk about what registered broker dealers, firms should think about doing. We'll talk about what registered professionals may think about doing, and what unregistered firms and unregistered intermediaries can think about doing. So we'll kind of try to talk through some of the points along those what am I to do type questions. We'll also talk about what's left to do, and that's primarily the states, but also a little bit of fundraising. So we'll circle back to Mike on that. And then we want to leave time for answering your questions, those that have been posed, and others that may pop up. Finally, the appendix to this slide deck actually has the text of the exemption, and so you'll have that available. It's pretty straightforward, and we'll talk about the different parts of it. So with that, we'll dig in. part one here, we're going to talk about the federal M&A broker exemption. This is an amendment to the Securities and Exchange Act of 1934. That's federal law. And what the exemption did, or the amendment did, was create an exemption from registration. If the qualifications of the private company and the M&A broker are satisfied, the M&A broker can rely on this exemption from registration. If the transaction involves securities, it's still a securities deal, and federal and state anti-fraud prohibitions still apply. The SEC's jurisdiction still applies. You just don't have to be registered as or with a broker-dealer to be an intermediary or consult or advise about these qualifying private company M&A transactions that involve securities. None of what we're going to talk about today has any impact on transactions structured as purely cash for assets. There's no securities involved in those kinds of transactions. None of this applies to that. And so those non-securities transactions are simply unaffected. They never were subject to federal securities laws because they don't involve securities. So lastly, key point here is this is talking about M&A. It is not and does not cover capital raising. You still need to be registered as or with a broker-dealer to be engaged in capital raising that is outside of the M&A context. The exemption largely codifies the 2014 SEC staff no action letter. And because the no action letter is a little different than the statute, the no action letter very likely will eventually be withdrawn by the SEC staff. And the key difference and why it's probably will be withdrawn is that there are size caps in the legislation, in the new law, on the target company, and we'll talk about those. But the size caps were a political consideration in getting this law passed because we knew we would face, and we did, opposition from the Wall Street type investment banking firms because they like their barriers to entry into their business. And so the no action letter, while it has no size caps, would have been impossible to pass as a matter of law without having these size caps in here. Again, to emphasize, securities laws in a securities transaction still apply. SEC jurisdiction, all anti-fraud prohibitions, material misstatements, material omissions of information, all of those prohibitions still apply. This is simply an exemption from having to be registered as or with a broker-dealer. And then important to note, and we'll talk about it, state-level broker-dealer exemptions are still needed in about 30 states plus the District of Columbia. So let me quickly recap what is the exemption, what's affected by it. Again, it's registration only. You're no longer required to be registered as or with a broker-dealer in most private M&A securities deals. As Kylene said, it's effective March 29th of this year. That's 90 days after the amendment became law. That is to say, when President Biden signed the massive federal funding bill for the federal government for fiscal year 2023, our 5 pages were among the 1,650 pages in that law. And there's a 90-day delay in effective date. The effective date is March 29th. I would say the law itself has no stated retroactive effect, but it would be fair to argue that the statute codifies the prior staff no action letter that was published way back in 2014. That's not bulletproof, but it does help you if you were challenged for a transaction that occurred prior to March 29th. Because essentially it was the law now codifies what the SEC staff had said was their no action position. So it applies to private M&A transactions involving securities, regardless of the deal's ultimate structure. And that's important because when you start an engagement, as you all know, you don't know what legal structure that is going to have. Could be stock sale, a sale or exchange of securities, or cash for assets where it still involves securities. And as we've noted in some prior programs, sellers' notes and earnouts potentially could be considered securities under some circumstances. So purely cash for assets at closing probably do not involve securities and are totally unaffected by all of this, including, I know there are some questions around the prohibition on custody, and that is to say escrow of earnest money deposits. In cash for assets transactions, purely cash and assets, no securities, those prohibitions don't apply under this law. It's only if it involves securities. So it only changes federal law. It does not in any way change state law. So as Kylene noted, state real estate and business broker licensing laws continue. If they were on the state's books before, they are still on the state books now. And so you really want to carefully consider state level requirements and exemptions we'll talk a little bit about. Scope, we're talking private company M&A transactions. Here is where the exemption includes a definition of the target company. The definition is in the exemption referred to as an eligible privately held company. This is important because it has to be privately held. The exemption does not cover and doesn't protect you if the transaction involves buying or selling SEC registered securities. That is to say, this exemption does not apply to what are commonly called pink sheet public companies, companies that have a class of registered securities with the SEC, and so technically are public companies even though they may be thinly traded. This exemption won't help you with that. Those kinds of companies might consider deregistering their securities and essentially going back to being privately held and privately not traded. But if they have registered securities, it is not covered by this exemption. The size caps I mentioned, there are alternative target company size caps. There are two different metrics here, and either of them, either or both of them, define the eligible privately held company. And the two metrics are designed around the fact that some businesses have high volume, low profits, and others have high profits, low volume. So there's a metric of 250 million in gross revenues or $25 million in EBITDA. This has to be the book, not adjusted. It's pretty common with privately held companies for M&A intermediaries to try to normalize revenues and take out sort of expenses that are unlikely to be attributable to a buyer because they really are the incorporated pocketbook of the seller. Can't use those. You have to use book for this because there really are no real legally established parameters around what adjustments might be made. So you have to go by book, and you look at the most recent fiscal year ended prior to your engagement. So you want to look at the book financials, and you want to look at their actual financials. Another important qualification, it needs to be an operating company, not a shell company. And there's two kinds of shell companies here. One's good, one's bad. So the bad kind are the special purpose acquisition companies, better known as SPACs, where they've been formed. Sometimes they are already registered public companies, even though they have no operations, and they're designed to be merged with a private company to take it public. That is not eligible for this exemption. The SEC has had all kinds of heartburn around those kinds of SPACs, and this exemption does not apply to them. The kind it does apply to, and very commonly are used in M&A transactions, would be triangular subsidiary mergers. That's where the acquirer forms a newly incorporated entity as a subsidiary or an affiliate, and there's either a forward or a reverse triangular merger so that the target company merges with the subsidiary of the buyer, and those are okay. The exemption itself in defining an M&A broker really requires three things that the M&A broker must reasonably believe. And the whole concept here, reasonably believe, is you don't really know at the front end of an engagement that these are ultimately going to be true. You won't know that for months, maybe longer. But in order to create this exemption, you have to reasonably believe these three things. You need to reasonably believe that the buyer is going to hold a controlling interest, and there's a presumption that the controlling interest exists at 25% or more ownership. It's not exclusive. There could be other ways at a lower ownership threshold, but the presumption kicks in at 25%. So you could sell a quarter of a business in something like a recapitalization transaction, where you're taking out one of the owners and you're bringing in a new owner who is going to acquire at least 25% or more, and therefore have a controlling interest in the company going forward. And the buyer, you have to have a reasonable belief the buyer will be active in the management of the business post-closing. The exemption itself says directly or indirectly, and there are non-exclusive examples of how the buyer could be either directly or indirectly active in the management. Could be a board seat, could be an executive C-suite officer, could include approval and control over the company's budget. These are things that actually came out of the SEC staff no action letter, and they're not exclusive, but the key there is having a reasonable belief that these two conditions in particular will be satisfied. These reasonable beliefs can be evidenced in a number of ways. There's no record keeping requirements in this exemption, but as they say, if it ain't in writing, it never happened. So you want to think about it defensively, to have some documentation that you're building, ideally at the front end, but could be later, that you're basing your reasonable beliefs on. So it could be in the engagement letter where you kind of generally describe among the many kinds of transactions that could be contemplated, you could refer to the fact that it could include these things we point out, that the buyer is going to hold a controlling interest and going to be active post-closing. But it can be other documents too. And in Florida, in particular, and Mike, I'll just throw it quickly back to you. Florida actually enacted their exemption by lawmaking rather than rulemaking. And of course, legislators love to tinker, and they did in Florida. Mike, what's the Florida requirement?
Well, the Florida law was changed very early in the process, and because they were on the leading edge, they added the requirement that the broker needed to get a written assurance from the seller and a written assurance from the buyer that the buyer would be a controlled person as defined by the statute after the closing. So there are forms that have been provided by the business brokers of Florida to all of their members, and closing attorneys in Florida have these forms, and they get them signed at closing, attesting to the fact that the buyer is going to be a control person.
Got it. And there you absolutely have, and you could adapt those forms for your own use, and they're not required in other states, but nonetheless can be could be useful. Again, it's no specific record keeping requirement in any state other than Florida, but you really want to have some tangible evidence that you can hang your hat on. Not required, but it's helpful to have something to point to. The third reasonable belief is really those transactions in which the seller is going to be offered the buyer's securities. This would commonly occur in an equity rollover, where the seller is going to be asked to invest some portion of the sale proceeds or the owner's interests as a seller in the buyer's entity post-closing. So in this scenario, and this is where you would, if you're a seller's on a seller engagement, you're really looking out for the seller's interest. So what would the seller want to see if the seller is going to invest in the buyer's company post-closing? And so this particular condition is designed, and it was presented to Congress as a way of assuring that sellers are going to be protected when they're asked to be reinvest in the buyer going forward. So the buyer needs to provide the seller at or prior to the time an offer of its securities is made. They need to provide the buyer's last fiscal year financial statements, again, actual financial statements, provide a current balance sheet within 120 days, provide a management's discussion and analysis of the fiscal year's performance. This doesn't need to rise to the level of a public company's MD&A, but needs to basically put a little color around what the financials say, and must disclose material loss contingencies. So these are things that if you're representing the seller, you want the seller to know what their risks are in essentially investing in the buyer going forward. And so this requirement, and again, as I mentioned, seller's notes or earnouts, depending on the particular facts and circumstances, might be considered securities. There are ways of mitigating that risk, but nonetheless, they could be. And so an analysis of the buyer's form of consideration at closing is still going to be important to figuring out whether this third reasonable belief is something that you need to address in the process. Finally, important to note, there are conditions to the exemption. The conditions really are the guardrails that the regulators, the SEC and the states, found acceptable in view of the fact that the protections of federal and state securities laws that really are designed to protect passive investors, and primarily in public companies, but especially private and passive investors. These are the guardrails that really supplant that whole square peg round hole problem with federal and state securities laws. And these conditions are designed to establish some basic parameters. First one is that the M&A broker in a securities transaction, this doesn't apply to transactions not involving securities, but in a securities transaction, in the M&A transaction, you as the intermediary cannot have custody, possession, control over the money or the securities. So if you're have an earnest money deposit, you have to make this work, you have to use a third-party escrow agent. And again, this only applies in securities transactions. And I would say in practice, I think most transactions that involve an earnest money deposit are very typically Main Street transactions, not middle market transactions. Be very unusual to have a earnest money deposit in a middle market transaction. So it's in that specific context, though, that M&A transaction involving securities, the M&A broker cannot have custody, possession, or control of the money. And that's Bernie Madoff right there, is the whole notion that somebody could make off with the money, and that's the reason for that condition. Second condition, cannot be engaged in a public offering of securities. Now, important to note, a public company can be a buyer, but not in a public offering of the public company's securities. Still possible that a public company could use its registered securities, but not in a public offering. So, and here, the whole notion the regulators focus on is public companies have a whole body of federal law around the regulation of public companies. And that's just not something that an unregistered M&A intermediary necessarily knows about, understands the risks of, and all. So cannot be engaged in a public offering of securities. Third bullet point here is another regulatory concern that the M&A broker or intermediary cannot be directly or indirectly providing deal financing. So for example, PE firms, VC firms, venture capital firms, they can be a buyer, totally fine, but they cannot rely on this exemption for themselves to take a success fee on the purchase or sale of a portfolio company that's going to be owned by their fund. That's double dipping. The SEC very concerned about PE and VC firms who, on top of all of their ongoing fund management fees, were also double dipping and charging success fees. It lowered the return of the investors in the funds, and the SEC's view was that VC and PE firms that would be involved, they obviously would be involved in the transaction, but they couldn't get compensated for a success fee. They could charge more on their management fee, that's fine, but not a success fee on buying or selling a portfolio company. That would be true for other circumstances too. Commercial banks, for example, that are providing deal financing cannot also rely on this exemption and themselves collect a success fee. The other condition kind of echoes the ones I've mentioned. You cannot be involved in a sale to passive buyers. Rationale is simply that's what federal securities laws are designed to do. They're to protect passive buyers. So that's a guardrail that says you cannot do that under this exemption. You cannot form or facilitate forming a group of buyers. Similar SEC concerns around the intermediary going out and forming a private fund of passive buyers and then turning around and collecting a success fee. It's really another flavor of the SEC's concerns around PE and VC firms who are double dipping on portfolio company transactions. And the last condition here is that the M&A intermediary cannot have a power of attorney that would bind their client, a party to the transaction. This is important simply because it distinguishes a retail broker from an M&A broker. Retail brokers can put in an order to buy or sell Tesla shares and it will bind their customer. And this distinguishes that. And it is an easy condition because I've just never ever seen it where the M&A broker had some kind of power of attorney, because it's the client's business that's being sold and a buyer. And anyway, that's one of the parameters here. There are in the exemption some good things you can do. You can be, for example, engaged by either the seller or the buyer. In fact, you could even be a neutral broker where, with disclosure and consent from both the seller and the buyer, you could be essentially a neutral intermediary. That's probably more relevant to Main Street transactions than middle market transactions, but it's covered. You can do that. You do need disclosure, what the comp is going to be, and that you're, basically not representing the seller or the buyer, and you need to get the parties' consent. Here's one really important. You can assist the client, in this case the buyer, in obtaining third-party financing. You need to disclose your role in your relationships and any related conflicts. For example, you could refer a buyer to a commercial bank, and you could, with disclosure, receive a referral fee from the commercial bank for the commercial loan origination that the bank will handle, but the M&A broker acts as the introducing party. You do need to disclose related compensation and conflicts, and that's an important guardrail. The other important guardrail is this does not cover capital raising activities. So it does not allow the M&A intermediary to go out and help the buyer raise money from passive investors or from others. It's sort of bring your own capital to the transaction. The M&A broker can't be involved in forming a group or forming a fund, and can't get compensated for capital raising activities. That requires a registration as or with a broker dealer. The couple more important things, the compensation that you as the M&A intermediary receive is not limited. The structure, the timing can be a combination of cash and equity or deferred payments. The M&A broker exemption doesn't impose any conditions around that. So you're completely free with in those respects. And as I mentioned before, there's no record keeping requirements. Think defensively, how do you prove those reasonable beliefs that I mentioned, but there's no specific requirement as to record keeping. Finally, there are disqualifications. These are sometimes referred to as the bad boy, bad girl, bad actor kinds of disqualifications. This exemption is not available if the M&A brokerage firm, its owners, or its management have been barred from the securities industry or are currently suspended from their registration in the securities industry. These are essentially saying you can't go through the back door what you can't do through the front door. So if you've been barred or suspended or currently suspended, you're not eligible to rely upon this exemption. And I would simply add to this, this is not in the federal exemption, but at the state level, it's entirely possible that state exemptions will pick up some additional disqualifications that are state specific and are that the state licensing laws or other kinds of criminal activity that the federal law doesn't pick up, but the states do. So that'll depend on the state, and that's just something that every state will want to chime in with what they require. So I'm going to pause there, and before starting on to the next topic of the states, and see, Kylene, do you want to see if you've got some questions that maybe jump out at you? Because I think I purposely tried to answer a bunch of the questions in my comments. anything kind of pop up that you can see, and I'll add if people have questions later that we don't get to, if they're submitted to Kylene on the webinar or emailed, we'll try to build those into a set of Q&As that we already have pretty well developed. And that'll be an additional resource that'll be posted on the website that Kylene mentioned. But Kylene or Mike, any questions pop up that we should hit at this point?
Well, you've done a fantastic job, and I have to say we're getting a lot of thank yous in that I just want you guys to be aware of. People really appreciate you going through this information. Although I have to tell you, Mike, I've had one comment. He's wondering whether this whole challenge has turned your hair gray since, over the past 16 years. So you have a friend in this audience that's having some fun with you. A couple of questions specifically, and if you said it, I've been trying to keep tabs and like check topics off here, so forgive me. Are folks allowed to advertise now that their transaction, that their opportunity is a stock sale?
Yeah, that's a great question, Kylene, and I see that in one of the questions from the last program. Here's a really important point. It depends on where you say it, because as I mentioned, if it's a securities transaction involving securities and you don't know that at the front end, when you're advertising on an email blast that is essentially a public advertisement, what you need to be careful is not inadvertently, by advertising a stock sale, you've blown the private offering exemption for those securities. And let me explain a little bit more about that. Completely apart from the fact that this is what we're talking about is the exemption of you, the M&A broker, the seller is still selling in a securities transaction their securities. And if you advertise a stock sale in an email blast, you have blown the private offering exemption for that seller to sell their securities, because it is no longer a private offering. It's a public offering, and it's not been registered with the SEC, which of course is prohibitively expensive and would never happen. So the takeaway on this is don't advertise in an email blast that this is a stock offering. You will shoot yourself in the foot and could have repercussions for having caused liability to the seller. That said, when you put together a confidential information memo, a SIM, a pitch book, a teaser that is not blasted all over the internet, that is specifically provided and usually with a non-disclosure agreement in front of it, a document that describes the kind of transaction that the seller is looking for. Frankly, that's part of that reasonable belief on those 3 points that we talked about earlier. And what's important is that that is not widely circulated. And that would typically not be widely circulated. You would typically not send a SIM or even a teaser that had company-specific information without having a non-disclosure agreement in front of it. And that non-disclosure agreement reinforces the fact that this is going to be, if it is a stock deal, this is going to be a private offering of those securities, that stock. And that is fine. You just, in contrast, and again, and I really want to emphasize this, you just can't do an email blast or post to a website, public website, that has no click-through confidentiality agreements or acknowledgments. You can't just publicly post that this is going to be a stock sale, because you will have blown the private offering exemption for the seller, your client. And but after you get a non-disclosure agreement and you limit the distribution of that kind of deal information, about the company, about the seller, about the kind of transaction they're looking for, that's fine. So I hope that kind of answers it, to beat a horse to death.
So we do have a lot of questions that have to do with the state. So I think, Shane, if you want to take us there to that next section, and then like you said, we'll pause for some more questions after that.
Sounds good. So the states, there are 20 states that through this process we have on board already. Out of the 20, there are 12 who adopted the model rule I'll mention next. And there are 8 of them that have adopted no action positions, interpretive letters, very much like the SEC staff's no action letter. These are the states. There are 20 of them. And the citations here are to where to look for them. Mike and I both have these and the detail around this. And Kylene, we can get you that for the website. To this 20, we are aware that Nevada is in the process of rulemaking. They're not done yet, but they're in the process of rulemaking. We're anticipating that Alabama will be. And so there's a couple that are likely to come along. I'll highlight there are a few states, we've not listed them here, a few states that have exemptions that are generally applicable and are not based on an M&A transaction. Washington State comes to mind. They just exempt private offerings, all types of private offerings, if the buyer or investor, and to that I would add the seller, but is an accredited investor. That's a really low threshold in the context of M&A transactions. It's not M&A specific, and you actually have to work really hard to find that because it's merely a cross-reference in the statute to another statutory section. So it's sort of following the thread through their statute to figure that out. But the reason it's not listed here is because it's not M&A specific. There are in most states some other exemptions generally applicable, but they have different conditions, different thresholds. Institutional investor is the primary one. But the definition of that varies in the states. Michigan, it's $2.5 million in a corporate entity. Other states, it's $10 million in a corporate entity. Other states, it's $100 million in a corporate entity. I can tell you clearly it does not apply to individuals, natural persons. So the 20 here, really important place to start because these are all, I'll call them fairly uniform. There are exemptions in some other states that are not at all uniform, but may be available. Finally, there are a handful of states that, like Florida, the regulator felt uncomfortable in trying to adopting the model rule that I'll get to by rulemaking, and in fact probably require lawmaking like Florida did. That means going to your governor, going to your state legislators to make that happen. And so it's just going to be a little different process in these other states. These other states do have available this model rule I mentioned. It was adopted by NASA. These are the other blue sky people, North American Securities Administrators Association. The model rule adopted and promulgated would be a better way to say it because it's not law. It's just a model that can be used by other states. Created in 2015, so there are a few differences between it and the final state of the federal exemption. And that's where we're going to try to work with Alabama to try to freshen, update that NASA model rule and get Alabama to adopt it. We're just at the early stages of that. And that freshened model rule could then be used by other states that would very closely harmonize the state rule with the federal law. Here, let me really emphasize, at the state level, state and regional associations are really the key players here. Contact your state regulator first, as they say, if you don't get what you don't ask for, and ask them, hey, did you know the federal law changed effective March 29th, and would you harmonize your law, your rule or your exemption with federal law? Bear in mind, these are state employees. Great people, to be sure, but they're state employees. They rarely do something unless somebody tells them to do something. So that's why you really kind of need to look at reaching out to your state governor. Very commonly, that's where you'll also have a state economic development agency and your state legislators. And it's sort of the pressure, a little political pressure. And as I say, some states may require lawmaking instead of just rulemaking. And Mike, do you want to throw in real quick some comments around what Florida did?
It was really very straightforward compared to the 16 years it's taken us to get federal law changed. It took us about 12 months to get Florida law changed. I reached out to the state Office of Financial Regulation, and they told me that they thought it was going to take a law being passed rather than simply a administrative action by the office. And so I reached out to my own state legislator. And like most states, our state is only in session for a couple of months out of the year. And it's fortunate that my state senator was a business owner. And so he immediately understood why this was important to business owners. And he took the lead and got a state representative to introduce a companion bill in the House. And by the time the next session of the Florida legislature came into session, they had a bill introduced in each house. They had committee meetings, hearings, and got the bill passed in one session. So it was not difficult at all. I was really gratified that getting something done at the state level was so much easier than getting something done at the federal level.
Indeed. Okay, we're running out of time, so we're going to click through these a little quickly here. So boots on the ground, the state and regional associations, you all have contacts with your state political leaders and even contacts with your state regulators. So that's where boots on the ground matter. And probably within a month or two, we should have that NASA model rule freshened into a form. It won't be adopted or republished by NASA until at least this fall. NASA only meets as an organization really twice a year, and their next meeting probably too soon is in May, and then their fall big annual meeting is in September. But we'll have some, and we're I'm happy to work with. Footnote, be engaged by state and regional associations to help in that effort. But let me quickly turn to state licensing requirements. And this is really just echoing what Kylene and said at the outset. State licensing requirements for real estate and business brokers. And I might add, there was a question about franchises. States regulate these things under their own laws. State franchise laws, many states regulate franchise brokers. And there are rules around purchases and sales of franchises. So that's all on the books. If it's in your state, you have to comply with that. Same thing for real estate and business broker licensing. This federal law doesn't affect that. And we know that there are an estimated 15 states that that do regulate real estate and business broker licensing, but have exemptions for registered broker dealers if you're registered as or with a broker dealer. That's a state level thing. This exemption at the federal level doesn't help you, but it is a consideration when you're thinking about what's next for you if you are registered. because if you give up those licenses, you might be giving up this state level exemption from real estate or business broker licensing. And this is a 50 state thing. It's well beyond the scope of what Mike and I can really comment around. And it's not at all affected by the federal exemption, other than kind of what's next. Real quickly, I just want to say we have slides in here around FINRA. FINRA regulation is really pretty misunderstood in the industry as a whole. SEC registered broker dealers must belong to a self-regulatory organization. That's a stock exchange or FINRA. FINRA is the default SRO if a B broker dealer is not a stock exchange member. FINRA's jurisdiction only applies to FINRA members and their registered professionals. FINRA's rules don't apply to you if you're not registered with a FINRA member broker dealer. So that's important. If you're not registered as or with a broker dealer, FINRA's rules don't apply to you. They may affect you, but they don't apply to you. And again, SEC registration, FINRA membership is required for anything outside the scope of this exemption. That is to say, public offerings, capital raising, fairness opinions, and other securities activities. And here's a list of the FINRA rules that really are primary around regulating M&A transactions. I won't go into them. We don't really have time. But if you're registered as or with a SEC broker dealer, who's of course a FINRA member, these rules would apply to you. So what's an M&A broker to do? If you're a member broker dealer, a firm registered as a broker dealer, you could consider moving qualified M&A practice that fits this exemption out into an unregistered affiliate, a parallel entity. It's not registered, but it's affiliated. There are still some state level uncertainties we talked about. Conceivably, if you, depending on how the broker dealer does the restructuring, it might require FINRA approval. And I would tell you I've done that. So it's been done and FINRA has approved it. So that can be done if you're a registered firm. You can, if you're a registered firm, rely on this exemption to pay a referral fee for these qualifying transactions to an M&A broker, a CPA, an exit planner, attorney. It has to fit under this exemption, but if it fits, the registered firm can rely on this exemption in paying a referral fee. What's the ongoing use or value of a broker-dealer registration? Well, capital raising and deals that don't fit under this, like public companies. So there are reasons if you're a registered firm to keep your registration, but you might set up an unregistered affiliate. For the individual professionals, again, registration still required for capital raising, pink sheet companies, fairness opinions, anything outside of the scope of the exemption. So before you just say, I'm done, I'm out of here, you want to think through what your kind of game plan is for anything that's not covered by this exemption. And there are still these state uncertainties, and because you would typically be registered with multiple states through the broker dealer that you're hanging your licenses with, you don't have a problem at the state level if you're registered. Other considerations before you just check out of your registration, some FINRA member broker dealers are resistant to paying referral fees for qualifying M&A transactions. There's a FINRA rule cited here. That's what they hang their hat on. They don't want to pay anybody if they don't have to, and the compliance department of most FINRA broker dealers is also known as the just say no department. So you have resistance among registered broker dealers. And this is all new to them too. So that's a reason why you don't just check out your licensing tomorrow. You want to think this through. The other important thing is your FINRA and state exam qualifications that you worked hard to get will lapse at 2 years after you terminate. And that's because you've not participated in ongoing continuing education. And so automatically they will lapse it after that 2-year grace period, and you would have to retake those exams in order to get them back. So you can terminate filing a Form U5 through your broker dealer, but think about it before you do that. And also check your rep agreements to see what happens to those engagements that you're in the middle of, that may be technically engagements that the broker dealer is sort of on paper handling. So you want to check your rep agreements for those. Finally, unregistered firms. And this may be a lot of folks out there. Review the state level exemptions in multi-state deals. So you have to realize that state level regulation is triggered by pretty much any state law is triggered by is the activity or are the parties in our state. And so if you had a seller in California, a buyer in Illinois, and you're located in Alabama, 3 states' laws will apply in that transaction. And so you have to think about where the buyer's located, where the seller's located, where you're located. And so think of that list of 20 states to see if you've, easily fit there. But you could consider expanding your M&A related services with success fees. Now, if you've just been an exit planner, you could now rely on this exemption if it fits everything we've said to expand your services to take a success fee. Update your engagement letters. Again, you kind of hear it's a place among others, but a place to kind of lay out the basis for your reasonable belief that we've talked about. And you can cite the new statutory exemption rather than the old 2014 SEC staff no action letter. And again, you want to look at retaining deal docs that support your reasonable belief. Look at updating your advertising and websites because now you could cite the federal exemption, and you could have new referral relationships. Again, has to fit within the parameters of these qualifying private company M&A transactions. But you could have referral arrangements with CPAs, business valuation appraisers, attorneys, upmarket M&A intermediaries, downmarket M&A intermediaries, so that deal flow can get where it really needs to be. So before we go, what more should I do? Mike, here I'm going to flip it to you.
Very good. Appreciate it, Shane. And thank you for going through all the twists and turns in the new regulation. We still need to raise some money to pay for the legal fees and lobbying fees we've incurred over the last 16 years to try to get this bill passed. Here's a summary of some of the sponsorship levels. I think the next slide is a contribution card that will be posted on the M&A Source and IBBA and BIEF website. And we would really encourage you to contribute your fair share to paying the legal bills and leaving some dry powder in the beef treasury for whatever the next issue is that's going to require an industry-wide response. These resources will be available on the website.
And here's some contact information for Mike, John, and Todd, and you have mine on the slide deck as well. Here's some links for other resources for the websites for updates, including IBBA and M&A Source and others. And so now there you have it. I wanted to try to get through all of this because I knew I could answer a bunch of the questions. But if you still have questions, feel free to shoot them across the bow here. Finally, I'll just note that the appendix, this is the exemption itself. And the beauty of this exemption is simply this. It says, in general, except as provided in subparagraph B, which is right below this, an M&A broker shall be exempt from registration under this section. So it's a sweeping exemption. You just have to fit within these guardrails, excluded activities, the disqualification we talked about, and then there's some key definitions about, remember I talked about the SPAC, what's a business related shell company, what is control, what is an eligible privately held company, and what is an M&A broker. And here, actually, Kylene, I really will pass it back to you. This is a very, very broad definition to say a broker, that's a statutory term in the 34 Act, somebody engaged in effecting securities transactions for others. But it's broad. It goes well beyond that here, and it picks up all of these activities. So, Kylene, there we have it.
Well, Shane, remarkable job. I keep line iting up. Yep, you hit that one. Yet you hit that one. I know we probably still didn't get to every question that's out there, but thank you for being so thorough. And I can definitely tell, you've been looking at people's questions and trying to respond to where the primary areas of concern lie. I do want to remind folks that yes, we will post this recording. It will be up on our legal updates pages. And Shane has also said that we can include this slide deck. One of the things that just strikes me is that, none of us like to spend the time reading anymore. We don't even like to read instruction manuals or whatever, but I think folks really do need to spend the time and read through this. As you said, it's pretty straightforward. And I think in total, it's about 5 pages when printed out normal, because a lot of the questions I'm seeing are straight answered if you do read through the text. I mean, certainly there are things that are going to need some interpretation, things that'll take place at the state level, but you have to start by reading this text, I think. So thank you both again for being here. I have to echo Mike's call to action. Don't think that, oh, this issue is taken care of, I don't need to do anything more, or don't think, oh, everybody else will take care of this issue. To give some of you some context, it's been, in total over $1 million of financial input needed to get to the place where we are with this. And there's still more to do. And so consider giving in whatever amount works for you. As I say, every little bit helps, and that's certainly true. The IBBA and the M&A Source have come together and have donated a combined $60,000 to beef to help get things started. I know of several state organizations that have made sizable donations as well. But if everyone within our industry just, gave some, we could really make some strong headway. And we know that there's still more work being done. We want to help support the states in advancing this locally. And so a lot of things that Shane's working on these days pertain to that. If you ever want the latest and greatest, the first place again to check are the legal updates pages. That's where we'll continue to post anything that we get from beef in terms of updates on states or anything pertaining to the passage of this act. Gentlemen, thank you so much again. And hope we might even see you guys at our upcoming conferences in May. That would be wonderful.
I have added it to my calendar.
Fantastic.
So bye-bye.
All right, I hope everyone enjoys the rest of your day. Until we see everyone again, take care.
Bye-bye.